Good afternoon, everyone. I'm Craig Cleland, and I'm the current president of the Atlanta Bar Association. I hope you are well, and I hope all those you love are well. And for those of you who may have lost loved ones, please know that you and they are in our thoughts and prayers. We are so excited today to welcome you to this January Zoom at noon. We have as our premier speaker, Alec Karakatsanis, who's the founder. I'm going to introduce both of our speakers today. Alec is the founder of Civil Rights Corps in DC, which many of you know. And before that, he was a civil rights lawyer and public defender in the District of Columbia, a federal public defender in Alabama, and then at that time co-founder of the Equal Justice Under Law organization. He's a grad of Yale College and Harvard Law, and just a couple of awards to mention. Trial Lawyer of the Year for Public Justice in 2016, the Stephen B. Bright Award in 2016 for contributions to indigent defense in the South by Gideon's Promise, and recently honored in 2018 as a champion of public defense from the National Association of Criminal Defense Lawyers. There's so much more we could say about you, Alec, but Alec has a fantastic book that I picked up about a year ago over at the Emory bookstore in the law section, and just jumped on it and read it so quickly. I was very taken by it, which is kind of how we got here today. Professor Fred Smith is a professor of law at Emory University School of Law, and in 2019, the school's outstanding professor of the year. Fred is our moderator today, has a great, and some of you will, I'll mention these folks because some of you will know them. He clerked on the Middle District of Alabama for Judge Myron Thompson, on the Second Circuit for Judge Barrington Parker, and most of us don't know her personally, but for Judge Sonia Sotomayor on the Supreme Court. And prior to teaching, worked at Bonder and Mixon here in Atlanta, which many of us know, and I think I was even a summer clerk there. Fred has taught federal courts in the fall, right, by Zoom, and turns out, I think folks did learn something. Fred was saying in our conversation, in spite of Zoom. Fred is a graduate at Stanford Law and Harvard College. Guys, we are so happy that you are here today, and we are honored. So take it and run with us and talk about whatever you'd like. I've taken probably 4 minutes into the hour with everybody joining, so please feel free to run over.
All right, great.
Thank you.
Well, thank you, Craig, for that wonderful start and introduction, and for the invitation. And thanks to everyone who is here. And thank you so much to Alec, who is a longtime friend of mine back from Alabama days. And so I want to start with the book, and just kind of give you a chance to kind of help us understand the various essays and kind of how it came to be one kind of book project. So can you just tell us about the essays that are in this particular book?
Yes, of course. Well, first, let me just say thank you to Fred for being here, and one of my dearest friends, and we've been through a lot together. We clerked together for one day. Then we spent, I think, a really formative trip together in Ferguson after the murder of Michael Brown, which we should talk about a little bit here today, and the work how that informed some of Fred's work and my own work after that going forward. And Fred has been on our board at Civil Rights Corps since its founding, basically, and is just an incredible person and friend. And Craig, thank you so much for the kind words about the book and for bringing us here today. I hope all of you will be interested enough to get a copy of the book yourselves. And all of the royalties from the book are being donated to an incredible organization called the SE Justice Group. It's ESSIE, It's an organization that organizes women with incarcerated loved ones. So you'll be supporting a great organization when you get the book. So yeah, Fred, I mean, I think just to take a step back, you know, the origin of the essays in the book, particularly the first essay, which is the centerpiece of the book and the longest one, came after many years of first being a public defender and then being a civil rights lawyer in the criminal punishment bureaucracy, and being taken aback by the ways in which the assembly line criminal punishment system had so normalized human caging that the people who work in it, and the broader public as well, are really desensitized to the brutality inherent in putting a human being in a cage. And what does it mean for all of us who work in this system that takes 11 million people every single year from their schools and families and jobs and churches and communities and medical care, mental health treatment, and puts them into government-run cages? And what does that mean for the children who are separated from their parents? What does that mean for people's bodies and minds? What does it mean for all of us? As I went across the country, I was seeing really horrific things that really should shock anyone who sees them to the core, and yet things that were so utterly normalized that we were not only doing them every day, but we were calling them justice. And you know, I opened the first essay in the book with the story of Charnell Mitchell. One of the first things I did when I got the grant from Harvard to start doing this work and quit my job as a public defender was I flew down to Alabama and I went around from jail to jail and court to court. I subsequently have done this all over the country, including in Georgia. And I have to say the things I've seen are pretty much the same, whether I'm in California or Mississippi or Pennsylvania or Tennessee. You see a courtroom packed with poor people, disproportionately Black people, who are being run through an assembly line. And that morning in Montgomery in 2014, I saw Charnell Mitchell, and she was one of 67 people in jail garb and shackles that day. And all of them were Black. And as I watched the court proceedings, it became clear that not a single one of those 67 people was charged with a crime. All of them were there because they owed debts to the city of Montgomery. And when I got up into the jail, I started interviewing people one by one. I made it through 5 people before they kicked me out of the jail and sort of realized what I was doing. But Charnell was the first person I met, and she showed me her court document, and it said, pay us $2,807 or do 59 days in jail. And by the time I met her, she'd been there for a couple of weeks. She had been sitting on her couch with her 1-year-old in her lap and her 4-year-old next to her when the police stormed her house, raided her house, took her away from her children, put metal chains on her, all because she owed some unpaid traffic tickets from 4 years prior in 2010. And Charnell, her debt was given to a private company, and she couldn't pay the private company, so the private company, who had contract with the city of Montgomery, put a warrant out for her arrest. And by the time I met her, she didn't know where her babies were. I mean, just imagine the feeling, not knowing where your young children are. Imagine those of you who have children, or those of you who know people who have children, like what that would do to you. And she was told, you know what, it's going to be 59 days in jail because it's $50 a day, but if you agree to be a janitor and to clean the feces and the blood and the mucus and the mold from the walls and the floors where she was sleeping on top of other women next to a toilet, if you agree to clean the judge's bathroom, we'll give you an extra $25 a day toward your debt. And in this way, Montgomery was essentially using a system of debt peonage labor to perform its municipal janitorial tasks. And you know, I took a photograph of her court document, which said she had to pay them this amount of money. And on the back of it, she had been writing in pencil 50 and 50 and 75 and 75 and 75 for the days that she could be a janitor. And she was calculating how quickly she was subtracting her debt from the $2,807 she owed so that she could get back to her children. I took a photograph of that. And I had no idea what I was doing. I wrote a federal civil rights complaint. It was the first time I'd ever really done anything like that. But I attached these photographs. And you know, we told, along with Charnell and the other people I met, each of whom had a story just like that. We don't have time to get into them all here in this talk, but they were just absolutely shattering stories. And we presented them to the federal court. And And the federal judge, who was a George W. Bush appointed former prosecutor, was so outraged at what was going on, he ordered all of the top city officials to come in person. And instead of doing that, the city of Montgomery just released everybody from its jail on a single day. And if I had to pinpoint sort of one origin for the book, that would sort of be it. I was really interested in trying to explore how it is we got to the point as a legal culture where we could so lose sight of the importance of individual liberty that we can be caging people, disproportionately Black people, all over the country, every single day without any reason at all. And in fact, solely because they owed money in many places. From there, right after the Montgomery case, Michael Brown was murdered. I went to Ferguson and embedded in with a lot of the organizers and protesters. That's when Fred and I spent some time there together. Fred was thinking about writing about some of these issues, and then I'll let him talk a little bit about this, but came to write a very important piece of scholarship called Ferguson, Abstention in the Time of Ferguson in the Harvard Law Review, sort of talking about all of the ways in which federal courts construct these doctrines to prevent themselves from really hearing these civil rights cases on their merits and confronting the way in which every single day our system shuttles people into cages. And then from there, sort of realized that the same flaws we were winning in these cases, this idea that no one should be put in a cage because she can't make a payment, that was the very core of the modern American money bail system. And so about 6 years ago this week, on January 15th, 2015, I represented a woman named Christy Dawn Varden, who became the first person to challenge the American money bail system on equal protection and due process grounds since the rise of mass incarceration. And then in the first 10 months of 2015, we filed 12 lawsuits in 12 different cities, including one in Georgia, challenging the money bail system as we know it. And we since have brought those cases all over the country. And I was mentioning to Craig before we got on today, and I can talk a little bit about this, but I just argued in the California Supreme Court a week ago, last Tuesday, on January 5th, to strike down California's money bail system, where several 100,000 human beings are detained every single year just because they can't make a payment, separated from their kids. So the book is an attempt to capture all of these injustices and to try to explain how it is they could have become so normalized. And then the second piece of the book is a real warning. Fred and I have talked a lot over the years about how sometimes things that are pushed on us as quote unquote reforms are really just an effort by the system to respond to a bunch of activism and energy, but to preserve as much as possible of the bureaucracy, to preserve the architecture of each of the oppressions, and to put the same mechanisms of oppression in place under different labels. And I'll give a few examples of that later. But my second, impetus, Fred, in writing the book was to try to capture the dangers of what I see in the criminal justice reform movement.
Right. So I actually want to draw a line from, basically it's the same line that you just drew, but I kind of want to tease out some of the legal theories here, right? So, we hear the story from Alabama, and there's so much of it that I think virtually anyone would find abhorrent, right? This kind of system of debt peonage that had been set up there, the $25 a day, et cetera. And there's different aspects of the story. The fact that, again, that most of us had never heard of that system before, the fact that it's in a region of the country that I think, even though we are in the South, there's still kind of an othering of the South that I think we ourselves psychologically do sometimes. So it has that component to it. And then you draw that line from there to money bail, which is everywhere, right? And as you noted last week, you argued a case in the California Supreme Court, right? So it's ubiquitous and it's familiar. And so what do they have in common? I mean, why are they a part of the same story as a way of, in the way of legal theory or in the way of morality and justice?
That's such an important question. I would say there's a few things they have in common just factually on the ground. Number one, the system in California, by most metrics of data is way worse than the system in Georgia. If you're talking about number of people detained, proportion of people detained, racial justice statistics, it's actually fascinating to think about because it goes against what some people sort of say, well, the South is just different, right? It's actually worse in most major American cities than it is in Georgia. You know, Washington, D.C., where I live, has the highest incarceration rate of any political jurisdiction in the world, higher than Louisiana. The Black people in D.C. are caged at 19 times the rate of white people, far outpacing the racial disparities in any other American jurisdiction. So I think there's several common factors. One, if you look at who's in jail all over the country, in every single jurisdiction, it's about 90% people who have qualified as indigent, right? So it's mostly very poor people. Number two, it's disproportionately people of color in every jurisdiction around the country. Those are two common threads. Another thing is that in every jurisdiction around the country, we've experienced what has now been called mass incarceration. You have to think about what that means. What it means is that no society in the recorded history of the modern world, including this society, has ever tried to take so many people away from their lives and process them through this bureaucracy. And that bureaucracy was not envisioned at the time that the legal institutions in this country were founded. It wasn't envisioned when the 14th Amendment was ratified, when the Bill of Rights was conceived of, right? When the liberties that we all sort of take for granted that are written on the marble monuments and in our constitutional scrolls, they weren't envisioning a society of mass human caging. In fact, they're completely incompatible. And so what had to happen all over the country was the legal system had to have a way of just processing all of these bodies. And the bail system is one of the ways it was able to do that. Instead of having a rigorous hearing for every single person about whether they should be detained or not, and what are the alternatives, it was much, much quicker and much, much easier to just set an amount of money. You don't need to have a hearing. You don't need to have a long process. You don't need to give the person a lawyer. You just look at a piece of paper and you come up with an amount of money. You're charged with theft under $500. Okay, bail amount is $1,000. You're charged with aggravated robbery. It's $5,000, right? So number one, it was a way for the system not to have really rigorous systems that would have gummed up the entire works of the system. Number two, and this is probably the most important one, pretrial detention is the only way that the system can possibly function because we couldn't possibly have enough jury trials for all the people that we're arresting. And when we did this really, we put the bail system on trial for the first time in US history in an 8-day hearing in front of Chief Judge Lee Rosenthal in the Southern District of Texas in Houston. And one of the most incredible findings that Judge Rosenthal made was that for people who couldn't afford to pay a few $100s just to bail out, they pled guilty 84% of the time. And they pled guilty in a median of 3.2 days, okay? For people in misdemeanors that could fight their case by paying just a couple $100s, they were more likely than not, after being arrested, to never get convicted of anything, have their case dismissed or to be acquitted. Their cases lasted a median of 120 days, okay? So the money bail system all over the country is a way of coercing very quick guilty pleas so that we don't have to provide investigative resources, counsel to litigate motions and file suppression hearings and fight the case, take it to a jury trial. Because everybody understands that if criminal defendants all did that, the entire system would break. And so the system of pretrial detention is our system's way of facilitating plea bargaining. And plea bargaining, as I write in the book, is required by Supreme Court precedent to be knowing, intelligent, and voluntary. And yet, who among us thinks it's voluntary? If you come to someone and say, you have a right to a jury trial, but if you exercise that right, I'm going to put you in a cage for 3 more years. Nobody under the ordinary understanding of the term voluntary would think that's voluntary. And yet, that is how we dispose of 95% to 98% of cases, depending on the jurisdiction, all over the country. It's a legal fiction that any of this is voluntary at all. but it was absolutely required, Fred, all over the country, because every single one of these jurisdictions is arresting so many more people than any time in American history and that any other country has ever tried. And that's enormous pressure. And then the third feature, Fred, I think why it's the same everywhere, is that the political forces, whether it's the sort of race baiting that we saw with things like the Willie Horton ad, and the financial forces that back up the system are the same everywhere. There's a tremendous amount of money to be made off of every single aspect of the system. So you've seen, for example, tasers and bulletproof vests and sirens and cop cars. Someone makes every single product that's used in the course of the criminal punishment bureaucracy. Moreover, you've heard of private prisons, obviously, but every single feature of every public jail and public prison has been privatized for profit. The medical care inside, the commissary, the food, the telephone calls. There's a controversy recently that I've been following and working on a little bit. The owner of the Detroit Pistons owns the largest private prison telecom company. And they diabolically worked with hundreds of local jails around the country to eliminate in-person visits over the last 8 years, on the theory that people will pay more for phone calls and video calls if they're not able to hug their children or see their children in person. And so this company actually set up a kickback scheme all over the country that's perfectly legal, where they give the jailers a cut of the revenue that they get from jailing people in exchange for the jailers eliminating in-person visits. So we can't, and then of course there's the multi-billion-dollar for-profit money bail industry, right? At every single turn. And then there's all of the unions. All over the country, one of the most powerful political forces in every jurisdiction is the union that represents the police officers and the jail guards. And they are a very organized, very effective political force. And so I think those are the things that come to my mind, Fred, about like what links all of these jurisdictions, even though they're sort of in disparate areas geographically, that we don't think of as having, the same politics.
Yeah, wow, there's so many places to go with that. This is the Atlanta Bar Association, so I'm also going to give you a chance to talk about the legal theory as well, if you don't mind. What makes this unconstitutional, or take your pick. I mean, obviously, you've named a lot of different things, and there's going to be different legal theories for some of the nuances. But can you give us a flavor of some of the reasons why, as a matter of existing doctrine, you said that you said some of these systems are entirely legal, and by that I assume you mean as a matter of statute. Why are they likely illegal as a matter of constitutional law?
Yeah, so I think we're at actually a very dangerous time with the judiciary, because things that we all took for granted and that we won in previous cases and in previous generations, like, for example, it's unconstitutional to put someone in a cage just because they can't make a payment. That's a really foundational principle that was most clearly and most recently stated by the Supreme Court in Bearden versus Georgia, a case out of Georgia where someone was jailed because they couldn't pay a fine when they were on probation. And the U.S. Supreme Court said it's unconstitutional to jail someone just because they can't pay. Well, I was doing an oral argument in the Fifth Circuit recently, which, like most circuits, is now 40% appointed by President Trump. And one of the newest judges from President Trump said to me at the oral argument that he thought Bearden was wrongly decided. And he doesn't believe that it's wrong to put someone in a jail cell just because they can't make a payment. So I'm going to answer your question about sort of longstanding doctrine and what my understanding of the doctrines are, but I actually think we're at a moment when the federal judiciary below the Supreme Court is so conservative. I don't say conservative in the sense of like Republican, because, we had done very well with Republican judges in the years prior to the most recent administration. And we'd actually done worse with some of the Democratic appointed judges, to be honest. But they have a very, very conservative view of the Constitution, and they don't think it protects hardly anything, particularly the Due Process Clause and Equal Protection Clauses. they that's how I'm using the term conservative. Like they are unwilling to use the Constitution as a way of correcting basic injustices in the system because they see it as some kind of intrusion. And so these judges actually want to overturn many of the Warren era and post-Warren era civil rights victories that were won in the courts. That's just an aside. I think it's going to be a very fascinating next few years because I don't think the Supreme Court of the United States is as conservative in that way. I think they're under some more significant constraints. But that all being said, the basic principle in many of our cases is that it's unconstitutional to put someone in a jail cell just because they can't make a payment. And jailing someone for her poverty violates both equal protection and due process. In Bearden, the US Supreme Court said there's a convergence of those two doctrines. It's both wrong because someone who is equally situated but has just a little bit more money would be able to pay and avoid being jailed. And it's also what the court called fundamentally unfair to jail someone for something that's not their fault. So that basic core principle, we've used in a variety of different contexts, whether it's jailing someone because they can't pay a fine post-conviction, like in Bearden, jailing someone, like this is a big problem in Atlanta and in Georgia generally, but jailing someone because they can't pay for a prosecutor diversion program. So choosing to go forward with a prosecution in Georgia because the person can't pay the fees associated with entering the program. We've brought a big case around that in Arizona. Taking away someone's driver's license just because they can't pay court debts. It's the same principle, right? Punishing someone just for their poverty. A second legal principle that we're litigating around the country is more to do with the bail system, which is that we have a fundamental interest in our bodily liberty. The Supreme Court has said for many decades that one of the core features of the Due Process Clause is that it protects bodily liberty against government intrusion. And what many courts have said all over the country is that if you want to take away someone's right to pretrial liberty, the government has to make a finding that there's a compelling interest that's served by it, that there's not some other set of conditions they could put on you that could reasonably protect the community before they detain you. That's a very basic, simple position. It's that liberty is so important that if you want to jail someone, you have to have a hearing where you put on evidence that shows that there's nothing else you could do that's short of jailing that could reasonably protect the community. We've been winning that argument all over the country. And yet last week, the Fifth Circuit, again, issued a very dangerous, very scary ruling that says there is no right to pretrial liberty. And if you think about what that means, if there's no due process right to pretrial liberty, the Georgia legislature or the Texas legislature could pass a law saying every single person arrested for any crime is detained prior to trial. So long as there's probable cause under the Fourth Amendment that you committed a crime, you're detained prior to trial. That's how scary some of what we're dealing with is with this new generation of judges who I think have a very different perspective on basic legal concepts. The third doctrine that we've been litigating a lot is a procedural due process doctrine, which is given that you have these substantive rights, the government must have a very rigorous process. You have to have a robust hearing with notice, an opportunity to be heard. You have to be able to confront evidence against you. If the court's going to detain you, they have to prove by clear and convincing evidence, a very high standard, that there's no other alternative but detaining you. You have to have a lawyer at that hearing, and the judge has to state reasons on the record explaining what evidence they're relying on to come to their conclusion. The procedural arguments have been very important all over the country because they sort of gum up the works of that assembly line that I just told you about. If everyone has to be given a hearing, a lawyer at a bail hearing and given these rigorous protections, and the judges have to write down their reasons, it actually makes it a lot harder to detain people. And that was one of the most important pieces in our settlement of the Houston case that I was talking about earlier, which is going to get about 18 to 20,000 people out of jail in Houston every single year alone. One of the most important pieces of that settlement was very rigorous procedural protections that make it very hard to detain people.
All right. I'm going to tease out a pessimistic perspective from some of the things that I've heard so far. Right. So far, I've heard that that the judiciary generally, and the federal judiciary in particular, might end up being a more hostile home to some of these claims than we've seen in recent years. I'm hearing that when it comes to the political economy of all of this, that there's a lot of folks who are deeply economically vested in this system. And the people who are economically vested in this system hold a tremendous amount of political power, and that's the site where you would typically want to be able to rely on courts to intervene. And so back where we began, it sounds like we might be in trouble there. So my question then is, how do we see our way out of this? How do we get to a place where we don't accept usual cruelty and where we kind of find a new way?
That's the question that keeps me up at night. I don't pretend to have the panacea or the best possible, most idealistic answer, but I'll give it a go. I think first and foremost, it's very important that we lawyers who see what's going on, who have this front row seat, that we don't allow ourselves to become the kind of person who is desensitized to things that should shock us to the core. Number one, we need to learn about what's going on. Number two, we need to organize together to do something about it. All these problems feel very daunting if you think about taking them on as an individual. But if you think about taking them on as a group of friends, a group of colleagues, a firm, a bar association, a community, they start to feel in a tangible way like problems that we can counter, that we can address. And so what are the avenues by which we can all come together? And just like the police unions come together, and just like the corrections officers unions come together, and build power. How do we connect with the communities that are most directly impacted by these systems? How do we give them a voice to tell their stories, which are deeply compelling, that most people don't get to hear? How do we work with them to create systems that don't destroy their communities and don't prey on their communities, don't extract their wealth, but that actually lift them up so they can flourish? I think those are the kinds of questions that we should all be asking ourselves. I don't